Filing a case is one thing and driving it into the right direction is another thing. Now, whenever you file a case in India, to get the desired outcomes, you have to file multiple applications. If you are a woman, today we will discuss 5 such applications that you should know or you must know before filing a divorce case in India, because these applications will help you to get the desired results. So the first application is application for return of Stridhan. Now what is Stridhan? Stridhan simply means that any jewelry, gift, belonging that you receive during the marriage and it solely belongs to you is a Stridhan. Now if your husband or your in-laws are refusing it to return back to you, you can file an application under section 27 of Hindu Marriage Act if any Hindu marriage petition is pending before any court. Let's say, for example, a divorce petition is pending before family court. So you can make an application under section 27 of Hindu Marriage Act for the return of Stridhan. See, if any domestic violence petition is pending before any court, so in that case, you have to make an application under section 19 of the Domestic Violence Act for the return of Stridhan. So the second application is application for interim maintenance and litigation expense. If you are a woman and you are unemployed or financially dependent, you can file an application under section 24 of Hindu Marriage Act to get financially support, monthly financial support from your husband. The court will direct the husband to pay monthly financial support as well as the litigation expense so that you can fight your case. The third application is application for protection order. So if you are facing any violence, harassment, threats from your husband or your in-laws, then in that case, you can file an application under section 18 of the Domestic Violence Act before any magistrate. Upon the application, the magistrate will pass the order and direct the local police to ensure your safety. This can stop the threats, the harassment, the other issues that you are facing from the side of your in-laws and your husband. So the fourth one is habeas corpus petition. Habeas corpus petition we generally file under section 226 of the Indian Constitution. So if your husband has taken away the child and refusing the child to return back to you after separation, then you can file an application or you can file a petition under 226 of Indian Constitution before your respective High Court to get the favorable order. In that case, the High Court will summon the husband and return the child back to you. Now the fifth application is application for injunction to stop the sale of the property. Now what happens is generally when the husband comes to know that you have filed a case against them, then in that case they try to sell the property or mortgage the property. So if your husband is trying to sell, mortgage or transfer the property or forcefully evict you from your matrimonial home, you can file an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure to stop your husband from doing so. So what court will do? Court will direct your husband not to dispose of the property until the case is decided.